everyone and welcome to SEO Explains. I'm Sai Spandana and today we'll be talking about the question of the validity of an unstamped arbitration agreement. A question so important that a 7-judge constitution bench of the Supreme Court recently reserved judgment in a case to clarify the legal position in the matter. So what is this case about and why is the Supreme Court debating an arbitration matter at all? Well, though arbitration is an alternative dispute resolution mechanism that is meant to reduce litigation, the Arbitration Act allows court intervention in some instances. For instance, the Act says that if the parties to an arbitration cannot agree on an arbitrator, they may approach the High Court or the Supreme Court to appoint an arbitrator on their behalf. Over the years, the Supreme Court has considered the key question in this case, that is, whether an unstamped or insufficiently stamped arbitration agreement is invalid in a series of cases. In 2011, in SMS Tea Estate versus Chandamari Tea Company, the court held that an unstamped arbitration agreement could not be enforced. They reasoned that sufficient stamp duty is essential for an agreement to be valid. In 2015, Section 11(6)(a) was introduced into the Arbitration Act. This provision states that while appointing an arbitrator, the court should confine its examination to the existence of an arbitration agreement. Seemingly, this provision suggests that the court cannot delve into the validity of an agreement under the Act. However, in 2019, in Garware Wall Ropes versus Coastal Marina Constructions, the Supreme Court held that contracts, including agreements, are only enforceable if they are duly stamped. The court also had a similar view later in Dharmaratnakara versus Bhaskar Raju in 2020. The present case, which is NN Global versus Indo-Unique Flame, arose in 2020. NN Global approached the Supreme Court over a dispute involving a bank guarantee in a contract with Indoflame. NN Global claimed that the agreement was unstamped and hence unenforceable. In January 2021, a 3-judge bench disagreed with the decisions in SMS Tea Estates and Garware. The bench also referred the case to a 5-judge constitution bench to settle the debate once and for all. Finally, on 25th April 2023, a 5-judge constitution bench of the Supreme Court comprising Justices K.M. Joseph, Aniruddha Bose, C.T. Ravi Kumar, Ajay Rastogi and Rishikesh Roy held in a 3-2 majority that an unstamped arbitration agreement was void and unenforceable. The decision, however, met with immediate criticism. Many claim that the judgment created practical difficulties and delays in the arbitration process, especially in urgent matters. Considering that arbitration is meant to be a speedy and effective mechanism to resolve disputes that do not require the court's intervention, the results seem counterproductive. On 26 September 2023, a 5-judge bench of the Supreme Court agreed to reconsider the NN Global decision in view of the larger ramifications and consequences it has. The bench comprised of Chief Justice D.Y. Chandrachud with Justices S.K. Kaul, Sanjeev Khanna, B.R. Gavai and Suryakant. Curiously, however, the lead petition in this case was a curative petition against the Dharmaratnakara decision in 2020. NN Global was a tagged matter. Over 11th and 12th October 2023, a 7-judge bench comprising CJI Chandrachud and Justices Kaul, Khanna, Gavai, Kant, along with Justices Pardiwala and Manoj Mishra, heard arguments about the NN Global judgment. The bench also renamed the case In Re Interplay Between Arbitration Agreements under the Arbitration and Conciliation Act of 1996 and the Indian Stamp Act of 1899. Senior advocates Arvind Datar, Nikhil Shakardande, Jayant Mehta, Gaurav Banerjee and Arias Kambhata petitioned that the majority decision in NN Global was incorrect. They highlighted that the court could not decide the validity of an arbitration agreement as its powers under Section 11(6)(a) of the Act were limited. The court could only determine the existence of an agreement and nothing more. Further, they also contended that not stamping or insufficiently stamping an arbitration agreement was a curable defect and could not be used as a yardstick to render the agreement invalid altogether. On the other side, senior advocates Shyam Devan and Nikhil Nair appeared for the respondents. Devan asserted that the court had no jurisdiction to answer any legal question in the present case. He contended that at the face of it, this was a curative petition. And by entertaining a petition to reconsider the NN Global judgment in a curative petition of Dharmaratnakara, the court was breaching the rules of curative jurisdiction. Changing the name of the case, he said, does not change the nature. The bench, however, reasoned that they had to hear the case as it involved a significant legal question. They assured Diwan that they would restrict themselves to answering this question and would not reopen the facts. Devan and Nair then went on to argue that the five-judge bench decision in NN Global was right to declare that an unstamped arbitration agreement was void. They said that under contract law, an unenforceable agreement was void. Therefore, an unstamped arbitration agreement which was unenforceable was also void. After 2 days of arguments, the bench reserved judgment in the case. The court's decision will clarify once and for all if an unstamped arbitration agreement is valid or void. This brings us to the end of this episode of SEO Explains. Read detailed reports about the case on seobserver.in and stay tuned to SEO Observer for more stories from the Supreme Court.